Okay, so what is discrimination under the law? You know, we discussed earlier that the law prohibits discrimination on the basis of disability, right? We've discussed what a disability is. We've discussed what a place of public accommodation is. So now the question is, if a business is a covered place of public accommodation, what can it not do relative to the disabled? And the answer is found here, specific prohibitions, discrimination. We're going to break this down into two different sections. This section here discusses, that I'm circling, discusses a failure to make a modification in policies and procedures. Those types of issues, for example, changing a policy so that service animals are allowed, are discussed later. This section requires that necessary auxiliary aids and services be provided. For example, an interpreter or an accessible website. That we're also going to discuss later. Right now, let's zoom in on physical barriers to access, architectural issues, parking lots, ramps, accessible restrooms. So, a failure to remove architectural barriers and communication barriers that are structural in nature in existing facilities and transportation barriers in existing vehicle and rail passenger cars. That part is not really what we're going to be focusing on. It's a failure to remove architectural barriers, okay? That's the bottom line. Buildings that pre-exist the ADA must remove architectural barriers to the extent that it is readily achievable to do so. And buildings built after the passage of the ADA or after the ADA became applicable have to be built in compliance with the ADA, unless there's some very limited exceptions, which we're going to discuss. But what does this mean? What does it mean to build in compliance with the ADA? What does it mean to remove architectural barriers? This is really the focus. This is the crux, this failure to remove architectural barriers of, in my experience, again, through hundreds of these cases, the crux of virtually all ADA cases that allege physical barriers to access. Okay? So what does it mean to remove physical barriers? Okay? In the law itself, 42 U.S.C. 12134, okay, the law says that no later than 1 year after July 26, 1990, the Attorney General shall promulgate regulations in an accessible format that implement this part, okay? So the Attorney General is being directed within a certain time period to come up with regulations that implement the ADA. Now, we've already looked at some of those because those are the regulations that are at 28 CFR Part 36. But in addition to the different rules and guidelines that we've been looking at, this also includes actual architectural requirements. So the architectural requirements that are necessary in order to remove barriers to access and non-compliance with which is considered discrimination are set forth in these regulations that are promulgated by the Attorney General. Okay, so I mean, I hope the way I'm speaking is not going to be too confusing. The bottom line here, because I don't want to make this more complicated than it needs to be, is that there's a guidebook, okay, and we're about to see it, and it says everything that you need to know. It says anything that any business needs to know, any person needs to know about the physical requirements of a building, okay? And those requirements have to be complied with unless there's an exception, and we'll discuss, when it doesn't have to be complied with or when it can be modified. But there's a guidebook. The guidebook says what you have to do. Unless there's an exception or a reason for not doing it, you have to do it or you're discriminating against the disabled. That's the bottom line. okay? And in fact, here we have the effective date laid out. We're looking at the actual regulations now. So the regulations themselves lay out when they become effective. And none of this really matters because it's the early 90s. We're so far beyond it now. The regulations became effective, a long time ago. And the first regulations to become effective were the 1991, the Department of Justice's 1991 Title III regulations, published on July 26, 1991. Okay, and these regulations, because a lot of them, even though there are more updated regulations, which are what we're going to be looking at, a lot of them are the same as the original 1991 regulations with respect to physical barriers to access. And so I still see in lawsuits plaintiffs' attorneys citing to the 1991 regulations because they just haven't changed. But in any event, as we're going to see in a moment, there are newer regulations, and those are the ones that I tend to look at for what the most current obligations of public accommodations are. And so let's see here. The next slide. Okay, so here we have the new regulations. These are the 2010 regulations issued by the Department of Justice. As you can see, we've been looking at them. Here are the different sections we've been looking at, 36.101, 0.102. And I'm going to have a link to this so that anybody can look at it. Again, it's completely free to look at and to read through. It's not terribly complicated to read and to understand what the obligations that it sets forth are. But this can be found, again, you can Google 28 CFR Part 36. A website will come up. It will tell you basically what all of this is. I mean, there's ada.gov. There are a lot of websites out there that will explain the different regulations. But these are the regulations themselves. These are the new regulations issued in 2010. They became effective as of March 15th, 2012. They've been updated a bit. This version says current as of January 17, 2017. So there have been some tweaks made. But in general, these are the regulations that we're going to look at, even if some parts of it have not changed since 1991. Okay, this is the 2010 ADA standards for accessible design. You can find it. I have the actual website right up here, but I'm going to have, as I said, some materials that are going to go over exactly where you can find all this with links. The next issue really is whether a business needs to comply with the 1991 or the 2010 standards, depending on when it was built. Okay, so looking now at this chart, which is at 28 CFR Part 36, Section 36, 3004D, this explains basically which standards, the 1991 or the 2010, had to be complied with depending on the status of the property at certain times. So before March 15, 2012, properties that were not in compliance with either standards had to comply, and they could use the 1991 or 2010 standards. Now you'll see here it says must be modified to the extent readily achievable. And that's always the case for existing facilities. And that's something that we're going to discuss in detail coming up here. I just wanted to give you a little preview of it now. But the bottom line is you had to comply with either the 91 or the 2010 standards if a business was existing before March 15, 2012. That's what it could do. On or after March 15th, 2012, the 2010 standards applied. So as of today, compliance has to be meet the 2010 standards. I mean, that's the bottom line here is, as of today, a non-complying existing facility, okay, has to meet the 2010 standards to the extent readily achievable. Now, buildings that were built prior to the 2010 standards that complied with the 1991 standards have a safe harbor. So, in other words, a building that existed as of 2005, let's say, was totally in compliance with the 1991 standards, has a safe harbor and doesn't have to update itself just to comply with the 2010 standards. Now, if it modifies or renovates or reconstructs a part of the building, including the accessibility features, that may be a different story. But in terms of existing 1991 compliant construction, the 2010 standards don't mean that that has to be ripped out. There is a safe harbor for that, but take a look at this section here and it will explain very clearly what the various standards are applicable to buildings on these various dates. This page should be very clear to anyone who reads it. And again, Google 28 CFR Part 36, Section 36.304D, and it can be read clearly. Okay, next. The safe harbor period that we were just talking about does not apply to areas that are governed or are regulated for the first time in 2010, which makes sense, right? Because there were no 1991 regulations to comply with in the first place in these areas. Now the 2010 regulations for the first time regulate these areas, and so there's nothing to give a safe harbor for. And this just goes through what those areas are. So for example, amusement rides, exercise machines and equipment, golf facilities, you can read it, shooting facilities, saunas. These are areas that are regulated for the first time within the 2010 standards. And so to the extent readily achievable, existing facilities that are covered, that are applicable to these various new areas of regulation have got to remove barriers to access. There's no safe harbor applicable.